Just trying to be civil, just trying to smooth things over.
Anybody else?
I want to say one more thing. My name's Chris Marshall. Live at 108 Womack Drive, Currituck, North Carolina. There's been a complaint back there recently. I don't know if y'all are aware of it, but as a teenager, I crabbed during the summer between school for 2 years and then quit doing it. My stepfather bought me crab pots and a boat and this, that, and the other. We always just recreational fish and duck hunt from the house. I've been in my neighborhood 45 years now. In 2003, I decided I might want a part-time crab because I'm not from a fishing family, and I always admired watching them guys go out there and make a living on the Sound. And I've lived on the Sound just about all my life. So in 2003, I went to Wanji's and purchased a boat and 100 crab pots and a couple trash cans full of nets and a license because they had a moratorium on the license. I brought the equipment home on the weekend. Monday morning, the county was there taking pictures. In a few days, I had a letter in the mailbox. It said I had 30 days to get the equipment off my lot, or it'd be $100 a day fine then. So I took that kind of threatening, so I followed what they said. Crab pots went away. I kept the boat, kept the nets, they're still in a trash can in my yard. And I kept the license. So I just find it, back then it was 2 ladies in the neighborhood that didn't want me to crab. One of them's deceased now, and the other lady's too old to worry about it. Now there's 4 people back there, which I've been in this neighborhood longer than anybody back there except for one lady. She's not one of the complainers. And it doesn't seem right that they can control that I can't keep 100 crab pots in my yard. I mean, that's all I wanted to do. That's all I want to do now is part-time. Because I can't do it for a living. I don't come from that background. But I can't even part-time crab with 100 pots in my yard. And I just think something needs to be, some kind of agreement needs to be come up. So that's basically what I want to say.
Any questions?
I mean, I've been there longer than anybody in the neighborhood, but 4 people don't want crab pots back there, so I can't crab part-time with the license that I'm spending good money each year to keep. I mean, what do you do with the crab pots? I don't have commercial property. So, yeah, that's it.
Any questions? Mr. McRae? Thank you. Mr. Stewart, did you have something else?
I just left off one little thing. I'm just going to give a statement that I've been here a long time. The zoning's changed and everything. I don't know a whole lot about residential. Y'all change it so quick that I can't keep up with it, so I don't ever pay no attention to it. But anyhow, I don't know what y'all got for residential area on your zonings and stuff, but I own 100 acres of marsh. The only thing can live there is a muskrat, and y'all got that zone residential too. So I wanted to bring that up to you. So that don't even make sense to me. Why would you have a residential 100 acres zone residential? I guess the only thing can live there might be a muskrat. Any questions?
Thank you, Mr. Stewart.
I don't believe in the zoning.
All right. Then at this time, I'll close the public comment part. Yes, sir. I'm sorry. Do we have one? Yes, sir. Did you?
Sir, I swore in.
Okay.
My name is Dan.
Yeah, go ahead.
My name is Dan Visser. I live at 116 Alex Lane, directly across from the business at 115 Alex Lane. I've lived there since 2004. I've raised my family there and now raising my grandchildren there on a part-time basis. Mr. Birch has had a residence across the street. He has had a business across the street when I bought the area, or when I bought the property. I have watched Mr. Birch thrive. I have complimented him. I have enjoyed watching a man prosper. Unfortunately, that has got to a point where it's too big for our neighborhood. As Ms. Berry has attested to, there are not just one business there, there's three. And there's separate employees for each one, as she has stated. There are also vehicles going out.
Motion to stricken that? Okay, I don't do that. Sorry, I thought you could do that.
There is vehicles for each one at any given time, and I will attest to it. There can be 8, 9, 10 vehicles. There's at least 6 parked there now, if you include trailers. We have, over the last 6, 7 years, listened to refrigerated units all summer long. It's 24 hours a day. It doesn't shut off at any time. It continues. We have worked with Mr. Birch. We have tried to work with Mr. Birch in this. We do not want to shut anybody down. It's the last thing I want to do. It's the last thing anybody wants to do. It's what this county needs, is commerce. Unfortunately, it's gotten too big for our neighborhood. The county has protected us, has set up protection for us in a way that it has to be out on a major thoroughfare, not in a neighborhood, a road such as Bells Island Road, such as Pointer Road, such as Tulls Creek Road, a major highway. This is in a neighborhood. We have kids here there. We, unfortunately, the traffic has got to a point where we can't handle it anymore. As stated, Mrs. Smith came out. We tried to work with him. The county codes enforcement officers came out. We tried to have a meeting in the street.
Mr. Birch.
It didn't work. It didn't work, unfortunately. This is what we put up with then also. We're not trying to shut anybody down. I've promoted his work. I've done work with him. I've done work for him for free. I like to see anybody prosper. That's not what this is about. We've never said anything about the odor. That was not on it. We've never said anything about the appearance of the place. Like they have stated, we believe that you keep to yourself. Unfortunately, it's got to a point where we cannot now. Quite a few times prior to 6 a.m., we get woken up 6 days a week to his workers coming in, his bait being sold. It wakes up every dog in the neighborhood. It wakes everybody up. We have tried in the past. Unfortunately, it came to this. There are other neighbors in the neighborhood that agree with me. We have a petition signed, if I can enter it, I don't know if I can or not, of all the, this is 9 different people that live right around the residents in question. Just asking that you please do not grant this appeal. It's what's protecting us right now. We don't want to shut Waterman down. We don't want to shut anybody down that's doing that wants to make a living. What we ask for is that you just protect our neighborhood. So we're not living across the street from anything bigger than it was, or bigger than it is now. We had no problem with it when Mr. Birch was catching crabs, had 300-400 crab pots over there, and he was loading them up and putting them in the back of his vehicle and leaving the neighborhood with him. Whether it was against county code or not, nothing was ever brought up. We don't want to shut anybody down, but unfortunately it's got to the point now where we rely on the county's codes to protect us. So we ask that you do not grant the appeal.
Any questions? Mr. McCree?
I don't have any questions.
Ms. Berry?
Yes, I object to him submitting the petition because those adjoining property owners are not here to speak and not available for my cross-examination as set forth by Mr. McCree on mine. Also, Mr. Visser, you say that you live directly across the business. Do you not actually live directly across from me?
That is correct. You stated that businesses are at 113 Alex Lane, 115 Alex Lane, and also 117 Alex Lane, which you also own.
My house was that stated in your citizen complaint? He was actually the gentleman that submitted the one written complaint. I'm asking if you submitted 117 Alex Lane in your complaint.
No.
So therefore, that's a moot point. You said that their refrigeration units were loud and waking you up. Were you also at that meeting when the sheriff came out and decided that there was, in fact, not a noise violation?
I was there when the sheriffs came by to take the noise soundings, and all the refrigeration units were shut off when they took those soundings. You are correct.
No, sir, they
So
were
yes,
not.
I was
moved.
present.
Stacy Smith, is that correct or not?
Excuse me.
Lisa.
One of you will do the speaking.
Yes,
That's Ms. Berry. Mr. Burke,
Please.
please, let's keep it in order. You asked Ms. Berry to handle it, let her handle
All
it.
right.
Ask her.
I move that per Stacy Smith's original testimony at the beginning, these units were turned on, just as a matter of record, not as a matter of reinstating what's already been stated. Mr. Visser, originally you said that you tried to work with us. Can you please explain what started this? Was it not Terry Everton's muffler?
One of Mr. Birch's employees,
Who lives at the house?
correct, that lives at the property, had no muffler on his vehicle. I asked if Mr. Birch would please ask his renter and employee if he could please put a muffler on his vehicle. And I also at the same time asked Mr. Birch if it would be possible to the gentlemen that are loading up bait at 5 o'clock in the morning, if they would please not just throw them into their trucks because it wakes everybody up.
But originally, this was over a truck of a gentleman that rented the house that was not owned by Mr. Birch.
He was an employee of Mr. Birch at the
He
business.
lived at the residence. That
Also,
was his
that's
home
correct.
with his wife and child.
Right, that's correct. But as stated,
Now-
he's an employee.
Is that why you decided to file this complaint in March?
No.
So what made you file this complaint after we started shipping all of our wholesale product and had cut? This was the least amount of traffic, which is claimed in your nature of violation, and the least noisy time of the year. So why would you pick March as opposed to, let's say, 3 years ago when we started shipping wholesale, when we had the most traffic and we had the noisiest equipment? Why would you wait 2 years?
Well, it was so difficult and bad in March that I made the complaint then.
What was so bad in March?
The noise,
From what?
the vehicles, as stated earlier, the commercial vehicles coming out.
From fishing?
The employees coming in and out.
From fishing? Was it?
Either bulkheading, fishing, in the fishing trade. It could be a combination of, I'm not sure which employees are working for which companies at which time.
But you stated that you did, and you could attest to which employees worked for which company.
No, I can't. Never did. They're just your employees.
Okay, I must have misunderstood. Now, you said in March, we had heavy traffic for fishing. Mind you, we only hard crabs, and the crabs haven't come out of the mud in March.
You may ask him
All
a
right,
question.
do you know the volume of crabs in March as opposed to the volume of crabs any other time of year?
No.
Would you say that that was our heavy period?
For crabbing?
Mm-hmm.
No, but I think the bulkheading business picks up, and so the same employees work for both. So the traffic for employees doesn't slow down much due to the seasons.
So you're saying that our majority of traffic is from our bulkheading business?
I think it's a conglomeration of all three.
But when you filed this complaint, it was over our bulkheading business that employs...
They're just running a business in a residential neighborhood.
All right, I was just trying to clarify a lot of commercial traffic.
There's a lot of people who get
Thank you so much for your time. I'm done.
In light of that line,
Yes.
I'm sorry, in light of that line of question, let me ask the
Yes,
witness,
sir. You may.
but who is it that lives at 115 Alex Lane, to your knowledge?
I believe Mr. Terry Overton lives at 115 Alex Lane, it's owned by Mr. Burke.
So Mr. Birch does not live at 115 Alex Lane.
I'm not sure which house he lives in, which house he lays his sleeps in the evening. He owns one and has a business partner next door, so I'm not sure which one he's living in.
So you don't know what he deems to be his residence.
I see him at both, so no, sir. I could not tell you where he lays his head.
I mean, further question.
Can I redirect another question? Does he park always at one or the other?
They have multiple vehicles, so I'm not sure which one he's driving. I see him in up to 3 or 4 different vehicles, and they're parked at both residences.
Since you attest to understanding his vehicles, can you tell us, does he use those vehicles for personal and professional or business uses?
I cannot attest to that. I don't know.
So you've never seen him go hunting or using any of these trucks that you say are solely for commercial use as personal vehicles? Like you've never been hunting with him, you've never gone to Virginia, gone to a concert using these same vehicles?
I have gone hunting with him, but I did not ride in a vehicle with him.
Okay, thank you.
Any other questions? Thank you, sir.
Thank you.
Mike Lavalny again. I have 2 residences. I have one in 104 Pike Street in Tulls Bay Colony, and I have a house. I live at 108 Alex Lane, which happens to be right next to or across the street from their business as well. I'm one house over, and we live there. I'm also a commercial fisherman. I don't keep any gear there to speak of other than minor stuff. But I live in Tulls Bay Colony, and I've had Miss Stacy's been out to my house. I don't know. I've got a bad neighbor, and she's been out there couldn't tell you a dozen times. I couldn't tell you. Never has she ever found any problem at my property. Never. I don't blame people. I mean, if I had a nice house, and I wouldn't want somebody to live next door to me who had crab pots, but you don't have that decision. It's not your decision. You own the property. You should go do with your property what you intend to use it for. Obviously, we don't want people jackhammering and making all kinds of noises or late hours or night. I'm one of the ones to go and get bait in the morning because usually I got something coming on. I can't get home. I don't go over to get bait until 7 o'clock in the morning. I've actually witnessed Mr. Birch coming out there, and one of the guys did throw a flat of bait not too long ago in the back of the truck. He come out and jumped all over the guy and said, "I got neighbors. You can't be knocking this in this truck." I mean, the guy, he jumped right in the guy immediately. I mean, he's doing everything he can to try to please all the neighbors and try to clean everything up and make everybody happy. It's a business. This whole county, there's nobody in this county don't come up there and go in their yard. Any street, there's somebody's got a truck in there. It's got handyman on it, locksmith. Everybody takes their trucks and park their stuff in their yard. Well, we go to work in the morning. We have to get in a boat. You guys get in a vehicle. A lot of people get in vehicles to go to work. We have to get in a boat to go to work. Okay, we have crab pots. That's our gear. It's no different than your briefcase or your hammer, your nails, anything else you take with you. We have to do the same thing. Unfortunately, crab pots are 2 foot square by 2 foot square. They take up a lot of room. We do the best we can to try and store them. And if anybody does have a complaint, we try to clean it up or do whatever. Nobody wants any bad neighbors. This just got out of hand. I live there. I've listened to it. I've been all a part of it. I'm a crabber. The problem is that this is not going to keep going away. This is going to be one right behind the other, right behind another. This is not just one person. This is all the rest of us guys out here too, are commercial fishing out here. There's not, there's maybe 2 dozen of us in the whole county. I don't understand why it's such a big deal. That's all I got.
Any questions from members of the board? Mr. McCrea?
No question.
Ms. Fair? Ask
Sorry.
a question.
My question, I'm going to be a third-year law student by the end of it. My question is, okay, so I just want to reiterate, Mr. Birch has told you personally that when loading bait, you need to be quiet and respectful of neighbors.
Yes, I was always respectful to start with, but some people are meatheads and
Have you,
jump on somebody's ass.
and you've seen us, have you seen us verbally reprimand
Yes.
anyone?
Yes, I have.
Do you consider our traffic to be excessive and ongoing?
No, I don't. And I know we got a UPS truck comes in here about every single day. I don't know whose house he goes to, but good God, QVC's making a fortune off of them.
Do you worry about, or can you attest to how many times our bait truck comes a week?
Usually once a week.
Can you attest to us trying to keep, per your, I guess, what have you seen as far as us keeping trash picked up, things in an orderly position, trying to keep all of the outdoor storage behind the sheds? Can you attest to what you feel is the visual quality and maintenance of the property?
They've done a lot to try to make the neighbors happy there. I was actually with Stacy when they did the audio, the little cop thing come out with a little meter, and both AC units. Actually, one kicked on while we were there. So one was running and the other one kicked on while we were there. So I mean, we actually did get good meetings, good readings, and actually I think they did a second time. The noise level isn't that. I mean, I live literally stone throws away. I sleep light. It doesn't wake me up. So nobody's going in there between the hours of, basically from 7 o'clock and, in the middle of the day, nobody's there until late in the afternoon. So people come bring the crabs, and it's just 1 or 2, 3 trucks come in, drop the crabs off, and everybody else is gone because 2 or 3 of the boats crab out of the yard. So.
Can you attest that you have gotten bait of your own accord without someone being there?
90% of the time I get my bait, nobody's there.
Thank you.
Yes.
My name's Cleveland Robinson. I live at 118 Alex Lane, right across the street from Lauren and Wayne. I've lived there for 4 years. Not one time have I been woken up early. I get up at 5 every morning to go to work. Trucks are never there, and if they are, they're there when I'm leaving. They are pretty clean. At first, I wasn't used to the crab thing. I'm from up north, so when I came down, I saw what I expected to move into. I knew what to expect. I met them. They were awesome. Didn't expect anything different to happen. 4 years now, it's improved a lot. They've cleaned up their lots. The guys that are there, it's just like anybody else. I have more people coming to my house because I run my own business. My guys, they don't meet me in my house anymore. They meet me after we get off work. We like to hang out at my house. I have about 10 trucks there. They might crash on, sleep in the tent in my front yard, and then wake up the next morning, break their tent down, and leave. Right next door to his house. So for over 4 years, they have never given me a problem. I've never smelled nothing. They've always kept all their stuff in order. My property value has gone up, so I don't know what is the problem with anything to do with crab in a residential area, especially when it's been there for 20-some years, So I'm all for the crabbers around here. And in my opinion, he's never done nothing. He's always kept his stuff nice and clean, never smelled anything. The AC, when it kicks on, it sounds just like anybody else's AC kicks on in their house. And that's about all I have to say about this man. He works hard, and I can't stop that.
Any questions from the board?
No question.
Mr. McCready?
No question.
Okay. I don't see anybody else getting up. So at this point, we will close public comment, and the board will begin deliberations. Now, as we talk, we may ask questions. We may ask questions of you, Ms. Berry, or of Ike, yes, sir.
I think you probably want to have them both have an opportunity to make closing arguments before you.
Yes,
you can go ahead and close the hearing, but before you start your deliberations,
right.
I would let them both have brief closing arguments.
Brief, sorry.
But let me finish.
Yeah.
Go ahead.
All right.
Ms. Beer, okay.
Thank you. Really quick, I'd like to actually point out a few instances. In 2009, there was a stakeholders steering committee that was established in Currituck to talk about this problem. It was kicked down the road again. Also, and when we started this, we tried to go about it the right way. We worked with the fishermen and the county planning staff to come up with a text amendment. On Monday, it was stricken down. We maintain that we are agriculture and goodness grows, and we didn't need to do that. However, being a good neighbor and in the spirit of, compromise, we tried it that way. It didn't work. I'd like to read a short excerpt from a report of the Fisheries Commission. It says, the protection of the fish and fostering of our fishing interests are not county questions, but state questions. They are not questions of the interest only to the individual, but to the whole people. And in passing laws to protect and foster our fishing industries, we must consider the state before the county and the whole people before the individual. And that was taken from 1908. This is what we do. This is who we are. This is what our county was founded on. And for as long as anyone can remember, including the commissioners as stated on Monday night, they thought it was fine. We thought it was fine. It is not cheap to start crabbing. And it is not easy work. But we did it, obviously, under the good faith that we were doing it correctly. Because everybody else had done it. And I know that's not a good argument, but based on the county's intent, in news articles and their past stance in this, based on the state's intent of recent legislature and House bills, all focused at the economic development of seafood and goodness grows products. In addition, the county or the state has spent millions of dollars on this marketing for Gotta Be NC Seafood. If commercial crabbers cannot crab out of residential zoned areas, there are not waterfront properties that's readily available that they can afford. I think I took account of it the other day on GIS, and there were 9 commercial general business zones on the water north of the Intercoastal Waterway. It's unrealistic, and there's been no movement on the county that has shown that they've ever prosecuted anybody else. So why here and why now? Thank you.
Mr. McCray.
Yes. As you understand, the Unified Development Ordinance sets out the types of uses that can be used in certain areas of the county. And in this particular instance, there is an exception that is made for what might normally only be allowed in a commercial or industrial area, and that's the home occupation standard. That's all that is at issue here. It has nothing to do with whether the county wants to shut down commercial fishing. It does not. But it's a matter of whether the operation that's being conducted at 115 Alex Lane meets the requirements and exception for the operation of a business in a single-family residential zoning district. That home occupation exception provides that a home occupation shall be permitted as accessory to any principal dwelling unit, provided that the accessory use will not change the character of the residential neighborhood in terms of appearance, noise, odors, traffic, or other impacts, and shall be subject to the following standards. And then there are listed 9 different standards that must be met. So it's not a matter of whether someone may operate their business from their home in a single-family residential zoning district. They can. But they've got to meet some certain standards in order to do that.
Now, you've heard testimony tonight that based upon the zoning officer, Ms. Smith's notice of violation and the investigation that she conducted, that there indeed are at least 1, 2, 3, 4, 5, or 6 violations of the 11 standards that are required to be met in order to have a home occupation operate from your property. First of all, the home occupation employs no more than one person on the premises who do not reside on the premises. We've heard the testimony from the applicant themselves that they have an employee who lives in the residential structure at 115 Alex Lane. That is not permitted in order to meet the requirements of a home occupation. Secondly, retail sales of products produced on site should be limited to lots with street frontage on a major arterial street. You've heard testimony not only from the applicants themselves, but from a neighbor directly across the street who says he's gone over and purchased crabs from them, that indeed there is a retail sale that's occurring on a street, Alex Lane, which is not defined as a major arterial street in the county, as testified to by Ms. Smith. Next, home occupation should not result in regular and ongoing vehicular traffic to the home where located. So we heard repeated witnesses from those who are neighbors and have an issue with this home occupation use, purported home occupation use, and from the applicant themselves who testifies to the regular comings and goings of different types of vehicles, whether it be crabbers picking up bait, whether it be trucks picking up product, whether it be, now we hear about another 2 businesses that are located on adjacent lots or maybe operate from this very same 115 Alex Lane, a bulkheading operation where employees are coming and going, which again does not meet the requirements and standards for operating a home occupation in this zoning district. And then lastly, the property contains no outdoor display or storage of goods, equipment, or services that are associated with the home occupation. Well, again, we've heard testimony from neighbors, testimony from the applicants themselves that indeed they have not met this requirement because they store in open areas equipment or crab pots or whatnot out in an uncovered area that can be seen by others. The whole purpose behind the home occupation exception, as you might understand, is that no one in the neighborhood should even know that there's a business being operated from that property. That's the whole premise and principle and the standard to ensure that the character of the residential neighborhood is not impacted. There should be no outward visible evidence of a business being operated from the property. And that's simply what the UDO requires. There's no intent to try to shut down a crabbing or fishing operation, but it's a matter of, yes, you may operate from your property at 115 Alice Lane, your crabbing and fishing operation, by meeting these 11 standards. That's simply what is being asked. Now, the applicant has made some argument that there is an exception, that they are exempt from all the county zoning regulations because of participation in the Goodness Grows in North Carolina program. But that is a failure to read the entire, all the language that applies to that particular section of the UDO, to the state statute, and to their argument. Because it's more than just having been admitted to the Goodness Grows in North Carolina program, but as we elicited through the testimony of Ms. Smith earlier in the hearing, it provides that the land used for the production of a non-farm product that the Department of Agriculture and Consumer Services recognizes as a Goodness Grows in North Carolina product that is produced on a farm, subject to Section 106743.2 of the North Carolina General Statute. So you can't just stop with, well, we're in the Goodness Grows program and we're exempt and can do what we want on our property. You have to then go to what is 106-743.2 of the General Statutes. Well, that's entitled Conservation Agreements for Farmland and Enhanced in enhanced voluntary agricultural districts. And it speaks to a conservation agreement that is entered into between a county and a landowner shall allow for an exemption for the production of non-farm products on that property. Well, you heard Ms. Smith testify that there is no conservation agreement entered into between the county and the applicant, and they've made no representation that there is. In addition, you heard Ms. Smith testify that there is no voluntary agricultural district that's been established in Currituck County, and you've not heard the applicant present any evidence that their property is in a voluntary agricultural district, and I would submit they couldn't even meet the minimum requirements for a single-family residential lot to be in such an agricultural district if the county determined to create one. So it's a misreading, misinterpretation, misapplication of the law to make a claim that because they're a Goodness Grows in North Carolina participant, that somehow they are exempt from the county regulations and can continue to operate as they see fit on this particular piece of property. So for those reasons, we would submit that for one other thing, I want to note that much of Ms. Berry's testimony, very passionate and impassioned, but it is an argument to be made in a legislative setting. And as you understand, this board, as much as you might want to step in and fix something legislatively or think there needs to be a fix, it's just not within your jurisdiction and authority to do that. As you know, this is the Board of Commissioners who are the legislators and who decide and make a determination as whether there should be an amendment or a modification or an allowance made in the Unified Development Ordinance. Now, you certainly can make a recommendation or suggestion to the Commissioners, but you've also heard that the Board of Commissioners has at least taken one stab at this and denied legislatively a text amendment that was presented by the applicants to the Board of Commissioners for consideration. There's not to say there couldn't be some other language that might be acceptable. But the legislative body, at least, has spoken as recently as Monday night that we are not going to modify or change the UDO to allow for a commercial business operation within a single-family residential zoning district, except under the terms and the conditions that we already have, which is the home occupation with these 11 standards that must be met. And when they are met, the applicant may continue to operate freely and pursue their business plans. So based upon that, the county would submit that the board should properly find that the zoning code enforcement officer was correct in her determination that there was a violation at 115 Alex Lane, and ask that you affirm that decision.
Okay. Now at this time, we will go to deliberation. I'm sorry?
Do I get a rebuttal or no? Okay. Too much law and order.
Thank you. As we discussed, what I was speaking to earlier, we will make comments, we'll have discussion amongst ourselves up here. It is not open for y'all to interject. We may ask questions of individuals, and at that time you can respond. And I'm going to ask Mr. Gallup. Mr. Gallup is the attorney to the Board of Adjustment. He is not a county attorney. He tells us in an unbiased manner the laws that we have to deal with. Mr. McCree alluded to the fact that we are not a legislative body. We can only apply the law. We can interpret it and apply it. We cannot change the law. We can't waiver it. It is what it is. So when we make the decision, it will be on evidence presented and what we perceive as the law as it stands, not whether we want it changed or not. And I hope that everyone will understand that as we move forward. Mr. Gallup, will you please clarify what we need to do here?
Thank you, Mr. Chairman. I think your statements about this body being a quasi-judicial body rather than a legislative body are precisely on point. What you do is you take the facts as were presented tonight and you apply them to the ordinance as it exists. And kind of like a meat grinder or a sausage grinder, you put them in one side and they come out the other, and you have a result. And what you're looking at tonight is a notice of violation that was sent by the county to the applicant that pointed out that the applicant was in violation of 4 provisions of the home occupancy ordinance. I'm not going to spell them out. You've seen them all. They're listed in your packet. But they basically, the retail sales, the vehicles, the regular and ongoing vehicular traffic, and the property with the equipment or display of goods. And what you would do is you would listen to the facts and see if any or all or none of those are met. And what you can do is you sit in the seat of the zoning administrator when she was making her decision. This body gets to vote and do the same things that she could do. And your vote will be either to affirm, which would be that you agree, to reverse, which would be that you wholeheartedly disagree, or to modify, which would be that you have some agreement or some disagreement, or you may have changes that would be in addition. But those are the 3 things that you can do. And I think that's pretty much the extent of it, is you apply the facts as you've heard tonight to those standards that the county says were violated, and you determine if the zoning administrator did that right. And if you agree that she did, then somebody would make a motion to affirm her decision. And if you disagree that she did, then somebody would make a motion to reverse it. And if there's some middle ground in there, then you would make a motion to modify and have to explain how the modification would work.
Okay. Very good. All right, then, members of the board, does everybody have their page before them with the items? You with us, Ian? Okay. Just want to make sure. Very good. Thank you very much. Thank you very much. There were 4 items listed out of the 11, and we will take them one at a time first. And then if there's any discussion on any other items, we will go to that. But the first item would be item number 5. Retail sales of products produced on site shall be limited to lots with street frontage on a major arterial street. And we are open for discussion.
It did come up about retail sales, and it was kind of obvious there was a limited amount of retail sales the way I saw it. And I'm not sure if that's where we are on the retail sales part or the street frontage, or is this a combination of the two? I mean, it's not on a major arterial street, granted, but I wasn't real clear about the retail sales.
It says that retail sales of products produced on the site shall be limited, so you can only sell the products if it is on frontage on a major arterial street.
Very well. So that's where we are on that.
Yes. Ms. McLeod? Questions, comments?
Are the retail sales produced on the site?
Retail sales of products produced on site.
That's what I'm saying. Are there products produced on site?
Well, they harvest them from the water and
But they're not produced on site.
Would we have to define a soft shell from a hard shell crab?
Are we here for the, see, that's why I have a little confusion. Are we here for the soft shell, or is it all combined?
It's retail sales,
but they're not any produced. I mean, the crabs are caught in the water and brought to the land, so that's not producing product on their that's where I'm confused on that statement of produced on site.
Mr. Gallup, can you give us some clarity on that?
I can attempt to. When you are trying to determine how to read the ordinance, the first thing you, and I've clicked on something that won't let me get back to.
Would you like my piece of paper?
No, I'm good. When you're trying to determine the ordinance, the first thing, you're trying to determine the intent of the legislative body that drafted the ordinance. And the intent of the legislative body that drafted the ordinance, you're trying to determine what they meant for it to say. And what you start with is the words and what they mean. If there's a question about what they mean, you use the ordinary dictionary definition. So we'll look up.
And I've done that before. I've looked
Produced.
up Webster.
We'll look up produced. To make or manufacture from components or raw materials, or to cause or to happen or to come into existence. Two definitions that come up first. I don't know that either one of those relate as much to food products as they do to other products. Another definition would be to bring into existence, to give rise to cause, as in to produce steam, to make or manufacture, to bring forth, to give birth, to provide, furnish, supply, or yield, such as a mine producing silver. Something that is produced, agricultural products collectively, especially vegetables and fruits, offspring, especially with a female animal. Those are the definitions I'm able to
So
find.
basically, you can look at it both ways. You can look at it as if it's something that's grown there, or harvest, or reproduced, or you can look at it that they're not producing. That's the way I feel about it, of what you just gave me as your definition.
I think there's some leeway in the definition, but I think probably looking towards the concept of manufacturing. You may produce a car at a plant, but that doesn't mean you didn't go out and obtain the roller from somewhere, the tire from somewhere, the screw from somewhere, the body from somewhere, the paint from somewhere, and then you put it together and you pass it along. I'm not sure that because you obtained the crabs from somewhere else that you weren't producing a bait product or a shedded soft shell crab, but that's your call as to how that applies. But looking at the definition and analyzing it and analogizing it to a manufacturing facility, I don't think it all has to come from the land for it to be produced, from that parcel to be produced.
Oh, no, right, because when you make cars, you're producing a car, but that, I just don't see where they're producing anything. That's
I
where...
think it's the creation of a final product.
Of crabs.
Well,
Okay.
I think it's the creation of a final product that's for sale to be
Okay.
retailed.
Yes, sir.
Mr. Chairman, also the back end of this talks about shall be limited to lots with street frontage on a major arterial street. So no matter where we are with retail sales, that is kind of a package there, the way I see it. So we would need to determine Alex Lane, yes, there are neighborhoods. Tulsa Bay Collins is a good example. Tulsa Creek Road runs right through it.
Okay, well, let's do a quick query. I understand your point. Board members, do you consider Alex Lane a major arterial street?
No.
No?
I have no clue where that road is, so I can't say yes or no.
Well, I do not either.
No, from looking at.
We're looking, I've been on it.
From classification given by Stacy? I mean, I know the road
By
well,
looking at
so-
that right there, I say, no, it's not a major road.
Okay.
And I think the only testimony that you had from anybody was Ms. Smith's testimony that it was not a major.
Yeah, she
It's not a
said it,
major
and I take her
arterial.
word for it.
Yes.
And I can just add that the UDO actually defines major arterial, and it's specifically US 158, NC 168, NC 34, NC 136, NC 615, and NC 12. Those are the major arterials in Currituck County.
In Currituck County?
Correct.
Tulsa Creek Road wouldn't even fall on that.
Bulls Creek Road would not fall on that.
Okay. So I was,
Okay.
okay.
All right, then the concept of retail sales of products. I'm trying to get us to a motion.
Well,
so
but we have to look at this in 5 pieces.
we're going to take each one separate.
Okay.
I think I might would discuss each one separate, but
Yes.
I think entertain a single motion.
Sure. Yeah.
Okay.
Okay.
I don't see where we're dealing with produced on-site retail sales. I think we're dealing with major arterial street. Because, we've been all over the place for retail sales and produced, and I don't see where we've defined that.
I don't see retail sales. I see
I don't either.
selling your neighbor some soft shells is not, to me, I don't interpret that as retail sales. You just happen to have them, your neighbor share them. But that's not setting up a side of the road and doing retail sales of your product.
So if you're not doing retail sales, the street frontage is not an issue.
For me.
Yeah, I personally don't see retail sales tonight. I've heard one person mention something about buying some crabs, and that was it.
Okay, so we resolved item 5?
Yes, I think so.
Okay. Item 6, all vehicles used in connection with the home occupation are of a size and located on the premises in such a manner so as to not disrupt the quiet nature and visual quality of the neighborhood, and there are no more than one vehicle per home occupation, and no instance shall any vehicle be larger than 8 feet by 32 feet be parked, stored, or otherwise maintained on the site of a home occupation.
The only difficulty I have here, it says no more than one vehicle per home occupation. And does that mean, is that provided only one person lives in the home, but if 3 people live there, you can have 3 vehicles? And I think we have to make that determination.
Used in connection with the home occupation. Personal vehicles do not apply.
Okay. So, but what I'm saying is no more than one vehicle per home occupation, which leads me to believe that more than one vehicle will be allowed, but there's different criteria for that.
Correct. This is more than one vehicle used in connection with the home occupation. They're personal vehicles.
Well, I'm not seeing where that's a problem.
And there was no, Stacy, you didn't have a truck that met that larger than that 8 feet by 32 feet parked there, did you? You didn't find one there by that size, did you?
No, ma'am, I did not find one larger than that. It was referring to the 2 containers that were sitting over there.
Okay.
But they were not larger than the size allowable, no.
So then,
We have the luxury here of more information than Stacy had.
right.
Okay.
So then, where is the problem on this one?
Well, I think, to me, we've determined that it's not. I mean, it's obvious the large vehicle was there, but no more than one. Again, I got to get past the no more than one vehicle per home occupation. That leads me to believe that more than one vehicle is allowed. However, it cannot be larger than this 32 feet, 8 feet by 32 feet. So now, how many vehicles is allowed? Is it 1? Is it 3? Is it 2? Because it says no more. I'm trying to do the original intent as Ben always tells us, is to learn the original intent of the legislation. And I see the original intent as saying they don't want a whole lot of vehicles around there, and because it's no longer a home. It is a business. So you want to maintain the appearance of a home without crowding up with vehicles. So where are we on no more than one vehicle per home occupation? And now we're talking about, 2 or 3 vehicles that are possibly there, but they are within the guidelines of the 8 feet by 32 feet. And I think that's where our dilemma is on this.
I think you're reading it incorrectly. It says no more than one vehicle per home occupation. And then in no instance shall the vehicle be larger.
Well,
You said there was no vehicle larger than
there is none,
It
so
doesn't, so you're not worried about that part. That's a separate part. In no instance. But there are more than one vehicle for the home operation there.
it says occupation. Does that mean occupants in the home, or am I misreading that, Mr. Chairman?
Per home occupation, that's the business that's
Oh, per
operating.
business.
Yes.
Per business, okay.
So does that mean the vehicles need to be registered in the vehicle's name or in the personal?
I don't think that's
Personal
irrelevant.
name.
That's
It's-
irrelevant.
If it's used in connection with, it can be bought, rented, borrowed,
Stolen.
but it can, if it's used in connection with the business, then it's considered business.
Okay.
Did we ever determine if there was more than one?
Yes.
I thought it was confused. That was also confused.
No, Stacy said there was more than one.
There's more than one.
Is that, am I correct in that, Stacy?
I am aware of the two. Give me 1 second, and I'll get back. If you look on the top, you've got the two containers on the left-hand side, top left. That was the complaint reference to the vehicles.
But
And
that's not a vehicle.
That falls under,
actually,
The
the,
back
Fall
one
under
is.
the-
that falls
Got
under
it,
number 10.
Because it's a trailer, it falls under
no,
the...
that's not outdoor storage. That's not outdoor storage, that's a vehicle. Or,
Okay, I mean,
Yeah.
I understand, but I was thinking it was under number 10 as opposed to number 6, but we still got to address number 10.
In that photo, there's a refrigerator truck to the right, and then the two other vehicles to the left.
And,
That's three.
Did someone say the Jeep Blue belongs to somebody else?
It doesn't matter if it's there and it's
there.
used for the
yeah,
business.
the white pickup, is that, Mr. Burke, is that your white F-150?
I'm looking at the vehicle to the right.
Far right, far right.
Far right, the refrigerated vehicle.
Okay, I see that.
Looking at that one is looking at that one.
Oh, that is a truck.
Yeah.
Well, I should have brought extra glasses. Wow. Okay, I got a wake-up call.
So what you're saying is that you can just
Thank you.
look in someone's yard and make a decision that those vehicles there are there for a business? I mean, there's not a difference?
I mean, we're looking at 7 trucks here. Okay.
Now, if you knew they were being used by the business, they would count, but I'm assuming business trucks are used for business.
Do you own all those vehicles?
I don't own 2 of them.
may I speak?
I don't own 3
Yeah, ask
of
the
them.
question.
3 of them are mine.
Okay. The one with the box, that is a personal truck. We use that to go skiing. That box is just like any other cab on any other truck. The red truck is Terry Overton's that lives in the house. The black Blazer is his wife's car, and the white truck is his cousin's. We do admit that we have the blue truck and the white trailer body. That we have 3 businesses.
How many vehicles do you pay personal property taxes on?
We're not going there.
Does that not matter? That's what.
Okay.
I mean, I'm just trying to see
No,
how
I
many vehicles they own.
Insurance is under personal names on those trucks. It does not carry
Do
business
you use it
insurance.
for the business? That's the question. If you
No.
use it for, it's-
I mean, the truck, that's his, no, really, no, because that's the Chevy, he'll use it, and then he parks it at my house sometimes, but we also get in that truck when we need to go to a concert. That's his that's our nice family truck. It's got the DVD player, it's got leather seats.
okay, thank you. Thank you.
So now we've determined there are 2 vehicles, and that being the white big truck and the blue truck that are for business.
Yes,
Okay.
that's more than one.
That's more than one, and that's where we are.
Okay.
Okay. Now this body has to determine.
No? Now we're going to number 7.
Okay.
Home occupation shall not result in regular and ongoing vehicular traffic to the home where located. There's pickup and deliveries.
There are.
The crabs aren't staying there.
And by regular and ongoing means it goes on all day and...
No, could be once a week. It doesn't say what the time schedule is.
Just regular and ongoing.
Yes.
We've made it, I realize that determination, Mr. Chairman. Anyone in discussion? No, I'm sorry, Mr. Chair.
Thank you.
I can't use not being the chair.
All right. Number 10, the property contains no outdoor display or storage of goods, equipment, or services that are associated with the home occupation.
Well, to me, Mr. Chairman, it's clear that this is some kind of business from the road. We're standing in the road where the picture's taken, and there's some kind of business going on there. Yeah, that's undeniable.
Okay. Mr. Fagler? Questions on this?
I'm still thinking on number 7.
On number 7?
Because crabbing business is not ongoing. It's not regular. It's seasonal. That's just my thought on that.
You're entitled to that.
It's a seasonal business. It's not ongoing. Ongoing and regular would be weekly, daily, monthly, yearly. And this is a seasonal business, crabbing this.
So they operate 9 months out of the year?
I don't know that. I can't answer that. I'm not a crabber.
I think she tested to 9 months out of the year.
One thing you may want to look at is at the time of the notice of violation, what Mr. McCree pointed out in his argument was that at any time, if this isn't a situation where they have to come and get a permit to have a home occupation, they just have to stay in compliance with these things, so that if any time they are in compliance with these things, then they aren't out of compliance.
Right.
So I think the question would be, at the time, what was the evidence of what was going on when the violation occurred? Was that at the time regular and ongoing traffic? I think that because the fact that they could clearly stop doing anything and they'd clearly be in compliance. They could do something and they might be out of compliance. I think that you have to look at what was going on at the time of the violation. If they're doing something again, the county will probably send them another notice of violation, and then they'll have another opportunity to appeal. They're going to get some guidance out of this as to what they need to or not need to do.
Okay.
But what you're looking at is, was the violation at the time, was what she said was going on true or not?
Did you witness the ongoing traffic?
Personally, no.
Because I've heard both sides testify to, or whatever.
I think you've heard mixed testimony.
Neighbors say it either way.
I think you have heard mixed testimony as to that time frame.
Right.
The notice of violation.
Say on that part. I'm finished with that one.
I didn't hear what you said.
The notice of violation that was sent in April.
In April?
Yes.
Okay. All right. Can we go back to number 10? The property contains no outdoor display or storage of goods or equipment.
Unless someone can come up with an argument, there is outdoor storage and there's something going on. And without walking around, I wouldn't tell what it is. But in view of that, can this body? I don't feel like we can deny that because we've been tasked to look at this.
Correct.
So this body may be able to look at a way to modify that number 10 so this person would not be offensive to the neighbors of the county.
How do you propose we modify it?
That's where we are.
We can't change the law.
What you can modify is the decision, and how you would modify it is, I think, if you found one of these but didn't find another one, you would modify the decision by reaching a final decision that was different based on different things than what the zoning administrator came to. I don't think you can modify what the law says.
Yeah, we can't change number 10.
No, we can't.
So you can't modify what the language of this is to meet the facts. You have to look at the facts and apply them to this language and see if this language is satisfied or not. And I think on this one, and Ms. Berry, I believe I heard her say, we admit that we have equipment stored outside on this one, and I think I heard Ms. Smith say that there was equipment stored in the back. I don't know that there's any evidence to the contrary that there wasn't equipment related to a home occupation that was stored outside. And I'm not seeing Ms. Berry telling me that.
I'm trying to be good and listen to regulations, all right? I'm not supposed to talk. You know, I'm over here about to bust.
But if I remember correctly, her initial testimony was, when she went through the things, was that she said, I think we are in violation of that one because there is equipment stored on outside of the property. And I believe Ms. Smith also confirmed that. So I think of all the ones that you have in front of you, it's going to be very troublesome for you to not find that one is satisfied.
Ms. Berry, the photo, are you able to see the photo I'm looking at? Okay, I just want to make sure. The greenhouse, this is the house of the violation, is that correct?
Yes, sir.
And you live in the house to the left?
There's a vacant, I own 3 lots. There's a vacant lot, and then there's my house, and then my other lot is behind it.
Okay, the tan building to the left, is that?
She moved.
That's our mom's house.
Yeah, that's his mom's.
Okay, all right. So
This here. That's my house.
you live to the right then, as I'm facing the property, you live to the right. Okay. And Mr. Birch, where do you live?
President lives with her.
So neither of y'all reside in the
Go to
house?
115 Alex Lane.
Neither of you
That is my 115 Alex Lane is where all my mail, everything goes.
Driver's license.
Driver's license still there. Everything's still there.
Okay, but Mr. Overton lives there.
Might
They're bosom buddies.
might sleep on the couch every once in a while, you know.
He's not good during the meetings.
Yeah.
I have a question. Obviously, this business has developed over the years, and the ODU has changed over the years. And granted, they've been found not in compliance to some of the rules because it's unhappy, this, that, and another. How do we make a decision that will help this position that all of these people are going to be in if we continue to point out to them, the ODU's changed and you can't do this anymore? That's what I want.
That's up to the legislative
I
body.
think there are 2 issues there. One is that it's, as Mr. McCree said, and as I've said, this is what I do. Sometimes I represent the legislative body for other towns and counties. Sometimes I represent the Board of Adjustment. Sometimes I represent folks like Ms. Berry and Mr. Birch. And all of the time, it's the same. The legislative body decides the policy, and we apply the policy. And the desire to help is a legislative desire. The other thing that I would say is the concept of a precedent isn't set in a true sense by a Board of Adjustment, not the way it's set in a court. You may end up having a similar case come before you in the future where you think about it a similar way, but every case should stand on its facts. And what you're questioning, too, is the similar businesses that may have lasted for a period of time. Maybe you're thinking of the concept of grandfathering, which was mentioned. And what that really is the legal term is nonconformity.
Yes, I'm aware of that.
And there's a difference between a legal nonconformity and an illegal nonconformity.
Okay.
Both of them no longer meet the ordinance as it sits. That's nonconforming. A legal nonconformity is one that was legal at the time it started. And that's a burden that has to be proven. You have to show different things. And that's where you get into the situation of every property and use is going to stand on its own, because you're going to have to deal with different defenses and different claims and different facts every time. So I don't know that there's any way for this board to appropriately
I've been inappropriate.
well, to disregard its application of the facts to the law in order to help. That's a legislative concept. If you don't find that the facts meet the law, then it comes out how it comes out. But to find that the facts meet the standards in the law, but then to come to a different decision is going to be something that is probably would not be upheld very easily on appeal from this board.
Okay, that's what I wanted to, okay.
Stacy, and I may be out of place asking this question, but what would these folks have to do to get this right?
Exactly.
Meet the standards of the UDO, the home occupation.
So you were saying these 4 things right here?
5.
1, 2, 3, 4 is all I see highlighted, isn't it? 5, 6, 7, and 10?
Technically, you have to meet 1 through 11.
Okay, but you only found the violation of those 4 highlighted, correct?
Well, actually, you're reading
All
from
or
the case analysis where those main items were highlighted out like we discussed, but if you are actually want to be technical, you should be reading off the notice of violation that was physically sent to them, not the case analysis. That's just kind of a background overview.
Okay.
So, and if you look, it was, in this case, you're in violation of standards. Reading directly from the notice of violation that you have in your packet in April was 3, 5, 6, 7, 10, and 11.
Mm-hmm.
So by upholding the county, we're in fact telling these folks this operation has to cease.
We're not saying they have to cease. They
I
have
understand,
to
but to be in
bring
compliance,
it, they have to bring it into compliance.
Thank you.
Questions, comments?
The only one I see that with what's been presented before me tonight is number 10.
I can't get around number 10.
All right, as we sit as this body, the direction would be to affirm, reverse, or modify. The citation was for 5 items. You can affirm all 5. You can modify to 1, 2, 3, 4, whichever.
Mm-hmm.
You can even add to it. There's the 11 items.
Right.
This body sits as an administrator, and we could find other if we so desired. Or if we so, it is a desire, if the evidence proved that one of the others was in violation, you would act on that. So at this time, we can decide on affirming, reversing, or modifying. Modification would be to affirm part, deny part, or maybe change part. And if you choose to modify, we have to spell out exactly what we are modifying.
I would entertain the fact No hair to pull out.
All right. If you take
I
it,
can't get around number 10.
okay, how about number 3, and we didn't go over that
Well, number 3 is not,
on the notice of violation.
okay, I'm looking here on this same page,
Yeah.
I'm sorry. And then we got other ones to look at, we hadn't talked about those.
Yeah, and actually, all 11
All 11, you
should be addressed.
correct. But the notice of violation was for,
So that's where we got out of sync, is we should have addressed them as if they weren't highlighted, though that was supposed to be to our advantage, and normally it would have been. Mr. Chairman,
yes, sir.
should we start back at number 1?
If you'd like, we can,
Mr. Chairman, the only things that the county found them to be in violation of were the items 3, 5, 6, 7, 10, and 11. So I don't think the county finds it necessary to go through all 11 at this point.
Yeah, I don't see the point of that either. The only one we haven't discussed is 3 of the violations, right?
okay.
I don't think you've discussed 11.
And we did not
that's right.
discuss
We did
11.
not discuss
So
11.
3 and 11.
All right, let's start at 3, and I'm going to ask for a show of hands as we move along so that we can keep it straight. Not a true motion, not a final, but at least keep it straight. The home occupation employs no more than one person on the premises who do not reside on the premises.
How many people work for you?
That's algebra.
On the land, me. On that piece of property, the only person working on that piece of property is me. The dock mama.
Stacy, when you signed this, or sent the notice of violation, did you find more than one person working on the premises that did not reside on the premises?
She doesn't reside at that premise. Neither does Mr. Birch. Harry Overton does.
Okay.
My mail goes there.
So,
That doesn't mean you reside
so
there.
how does, I don't understand then, who's is there more than one person working there that lives there? It doesn't matter who it is, does it?
Of course, this is, you will have need to determine, but more than one employee that does not reside at their residence. So if they don't live in the resident, you can only have one more outside of there.
2 people.
That are working there on that land, right? Or working for the business.
Says the home occupation employs no more than one person on the premises who do not reside on the premises.
So you've got a person that lives there and one more.
Right.
So I don't see where that's a violation, whether there's no evidence that there's a violation.
That's what I don't.
Okay? So,
I make a motion.
No, we're not taking a motion.
I'm suggesting that they're not in violation of number 3.
number 3 is not a violation. Zia, you all right on that?
Yeah, fine.
Okay. All right. Number 5, retail sales of products produced on site shall be limited to lots with street frontage on a major arterial street.
All right, you ruled that out a while ago, right?
Well, we discussed it, we didn't take a... First, I feel there is retail sales, and it is not a major arterial, but I'm one.
I agree with the chair. I can't get around. I just can't see any other way.
A while ago, you were the opposite.
No, I was that way before. I said, but despite the retail sales, it's definitely not a major arterial street, so I can't get around it. Please argue with me.
No, I don't understand. I thought a while ago that you were saying that this was not a violation. I guess I misunderstood you.
Yeah, you may have. You may have, because the retail sales, okay, I can't define the retail sales. You sold your neighbor a dozen crabs. I don't see where that's evidence, but the fact remains it's not on a major arterial street, so that's what it is.
Mr. Tabor, I think what you're saying is you have to have both to meet that provision. And I think everybody's in agreement it's not on a major arterial street. So the only question for each of you really is, do you see that there are retail sales? Was there evidence of retail sales on the property? I'm hearing Ms. McLeod say no. I'm hearing the chair say yes. I'm hearing you say no. And I think you're looking at the two as separate conditions, but just on the question of retail sales, do you believe there were retail sales or not on the property? Evidence. Do you think there was evidence of retail sales?
The sale of bait and the sale of...
That's not retail.
That's wholesale, it's not retail. Retail is when you go to Walmart and buy something.
You're end user.
So it's looking like 3 people say that that's not met and 1 person believes it is.
But
Retail,
you have to have retail sales before the road. Okay, so then you choose no on that one. Okay. Number 6, all vehicles used in connection with the home occupation.
No more than one vehicle.
No more than one. So where are we on number 6?
And that the one where we said there was not a big vehicle larger than the 8 feet.
Doesn't have to be.
Doesn't have to be.
It's just no more than one.
No more than one, and that one can't be larger than 8 feet by 32.
And that trailer doesn't fall from that past this measurement?
No, it doesn't. It's inside. That's not, the 8 feet by 32 feet is not an issue.
Okay.
It's more than
It's not an issue. It's that there's more than one vehicle. And I have to uphold the county on that, on number 6.
Okay. Where are you?
I don't know, because, I mean, some people say they're theirs, some people say they're cousins, some people say, I mean, yeah, when I look at that picture, there's tons of vehicles there, but who owns them is the way I feel.
Doesn't matter who owns.
No.
It's connection with.
But just because they're in their yard, how do we know that they're being used?
Well,
That you can choose to say no.
Well, there was some talk of the blue truck, but it's there.
I thought they narrowed it down to 2 of them with theirs. I thought that's what we were.
Okay, that's more than one. So that's why I had to uphold the county. There's more than one. That's where we are.
All right, whatever. There's 2 people there, so that's why I thought 1 for each person. So, okay.
So that's not what you. That's
not in the ordinance.
All right, move on.
Home occupations shall not result in a regular and ongoing vehicular traffic to the home where located.
I'm going to deny the county on that. I never was satisfied what regular and ongoing was. Yeah, I'm just not comfortable with that. I don't think there was enough evidence.
I agree with you, because we heard from both sides that when some said it wasn't, some said it was. So.
I don't see enough evidence to.
Stacy, and I think I asked you, you never saw ongoing traffic, right? Okay.
Well, she was going by the complainant, I'm sure.
Okay. The property contains no outdoor display or storage of goods, equipment, or services.
Well, unfortunately, we do have storage of goods.
Okay.
Yeah.
Very far confirmed that. Number 11, the home occupation does not create traffic or parking congestion, noise, vibration, odor, glare, fumes, or electrical or communications interference which can be detected by the normal senses off the premises, including visual or audible interference with radio or television reception. I'll make a note. While the Sheriff's Department has said that the noise level is not in violation, the ordinance here does not say that.
No, it does not.
It says it has to be audible. So if somebody across the street hears it, it is audible, even though it's not at the level of receiving a citation from the sheriff's department.
But if you'll allow me to read this to myself, because I'm trying to understand what you're saying.
But it says audible interference with radio and television reception. No one hears complaining.
Including.
Oh, I'm sorry.
Including. So in other words,
audible interference, right, including.
well, I've heard more evidence of it being a problem than not being a problem. However,
Vibration, odor, glare, fumes, or electrical or communication interference. Where, I don't see where you're saying that. The home occupation does not create traffic or parking congestion. Noise.
vibration,
Odor, glare, fumes, or electrical or communication interference.
which can be, and it says be detected by the normal senses off the premises. So that takes the sheriff's thing out of that's out of the equation. However, I did hear more evidence of it not being a problem than I heard of it being a problem.
I agree, because I can hear my brother's air conditioner turn on at his house.
I can hear my wife's dog snore.
That's a normal neighborhood noise, hearing air conditioners turn on and off.
Sure. But again, I feel like that, yes, it's detected by the normal senses, so we're taking the equipment out of the equation, so now we're putting the people in. I heard from more people that it wasn't a problem than I did without being there. And hearing the evidence set before me, which is all we have to go by, what is presented to us, my thinking is it's not a problem because there's more evidence of it not being a problem than there is of. And if it were the other way around, the reverse would be true. And that's all we have to go by.
I agree.
And it does not allow us to use the equipment that the sheriff used because there's no provision for that. That we have to go by the ordinance. So I move that there's not a violation of number 11. Yes. Okay. I don't see where 11 is a violation.
Now, I heard more people that live in the neighborhood. I only heard 2 people in the neighborhood that complained of the noise. Not many people on the common side had anything to say, it seems. And there was one other gentleman, but he wasn't complaining about noise. He's only been there 3 years, and he decided he didn't like it.
Okay. All right. Any other discussion on school? All right. Then I'll go back over. Per our discussion, the majority shows number 3, not supported, reversal. Number 5, not supported, reversal. 6 affirmed. Number 7, not supported, reversal. 10 affirmed. Number 11, not supported, reversal. Any other consideration for any of the other items? Then, any other discussion? Are we doing according to guidelines, sir?
I think you've duly deliberated your thoughts and consideration of each of the provisions, and it would be appropriate for, if anyone's ready to do that, to make a motion consistent with that.
I would be looking for a motion that,
and the chair, you can make a motion yourself if you decide. I know you.
I don't normally.
I know you don't, but you are certainly welcome to make a motion.
Well, then I will make the motion that this board, items 3, 5, 7, and 11, reverse the administrator's findings on those, and items 6 and 10 affirm the administrator's findings. Any further discussion? Ooh, second. Do I have a second? Okay. Any further discussion? All those in favor say aye. Aye. Opposed? Motion carries.
One thing I would add is if you could make a motion that the findings of fact be used to support those positions based on your discussions and deliberations.
Okay.
So a so moved would cover that.
So moved. A motion that the findings of fact support the findings of fact as through the deliberations support our decision in this motion. Second. All those in favor say aye.
Aye.
Motion carries.
And the only other decision to make is who drafts the order. While Ms. Berry, it is Berry, right, not Perry, has done an admirable job not being an attorney tonight. Normally, if there's multiple attorneys, the prevailing party, which would probably be Ms. Berry in this, would draft the order, but I would suggest that it's probably best that Mr. McCree draft the order and share it with Ms. Berry and myself, and we go from there, and that you direct that as the chair.
Yes, ma'am.
May I have another attorney draft the order? That's unbiased.
It would have to be
I'm
approved by
not saying
this.
you know what I mean? That's
It would have to be approved by this board.
okay. I don't.
It's our draft.
Okay,
I'm
cool.
sorry.
That's fine.
The board, the way this would typically work in a courtroom is that there would be an attorney at that table and an attorney at that table, and whichever attorney won would draft the order and share it with the other, who would, if they have objections, they would note their objections or say it was okay, and then
Okay.
whatever came with that would be shared with the body as to their decision on what the order was.
May I request layman terms in how to fix these problems? Like if we need to put up a fence, just layman terms, please, not something that regular people can understand. That way we actually can fix this. We don't want to be.
This board isn't going to be the body that will tell you that. That would be speaking
told
with
us the whole time. They haven't told us.
I can't help it.
We just now reached that point.
Yeah.
I have a building.
Okay.
Would you like Mr. McCree to draft the order?
Mr. McCree, can you draft
Thank you.
and get it to Ms. Berry for her
Yes, sir.
consideration? Thank you. Anything else? Board members, I thank you for your time and diligence, and I think we've been at it long enough.
It's not 10:30 yet.
Folks, thank you very much for coming out.
Thank
We
you,
are
sir.
adjourned.